web meeting sponsored Bureau of Justice Assistance Drug Court Technical Assistance Project, focusing on all of defense counsel, drug courts, and drug-related cases. This is one of the most important web meetings we're doing, and I thank everyone for joining. I'm delighted to see that we have over 150 participants. That's a mix of defense counsel, judges, treatment lawyers, computers, and a good array of others involved with drug courts and drug-involved offenders. This, as I mentioned, the first of a series of 3 that we're going to be doing. And our organization today is we're going to have the presentation of the principles and opportunity for you to ask questions, and then we'll have a follow-up session tomorrow at 12:30 Eastern Time to more of the questions that we don't get a chance to address now. So with that, I'm going to turn it over to Genevieve Citrin, who is going to introduce our panel, who are extremely knowledgeable about these issues. And thank you again for participating. Yes.
Thank you, Carolyn. And today we are lucky to have 2 former public defenders and now both professors here with us today. We have Michael Perlin, who's a professor of law at New York School of Law. He's also the founding director of International Mental Disability Law Reform Project and co-founder of Mental Disability Law and Policy Associates. And today we have Yvonne Segars, who is the former state public defender of New Jersey. She was the first drug court public defender in the state of New Jersey, and as the state public defender, was integral in spreading drug courts throughout the state. And she's currently a professor at the School of Criminal Justice at Kean University. So thank you both very much for being here with us
today. Thank you for having us.
Thank you.
So, first of all, Caroline, thank you very much for inviting Michael and myself. We look forward to this presentation, and hopefully we'll get to a lot of information today. I would first like to start out by saying that we know that those of you who are part of this call today come from very diverse backgrounds. So whether you are a public defender, an institutional public defender office, private counsel, assigned counsel, contract attorney from a smaller county or rural or urban jurisdiction, we are very mindful that we have a diverse group of attorneys on the call, as well as other professionals in different pursuits. We all are very cognizant of the fact that the court programs or the court programs you represent are different, whether they're diversion courts or post-education courts, mental health courts, veterans courts. We're also very mindful of that. But irrespective of the court you come from or at the point that you serve as your clients, we know that these issues are critically important to our clients. So it's clear to us that one of the greatest challenges is they, as defenders and court-appointed counsel, is what to do when we are representing our clients who we know have a substance use disorder and may have or may not have some type of mental health disability, disorder, or co-occurring disorder, or cognitive disorder. Those problems can range, intersect in our representation at any point, from the point of arrest to our interview, all the way through sentencing and post-trial. So how that happens is very critical. The goals today, we want to talk about, we'll share insights and our knowledge and our experiences to impart to you, but we'll of that population. But we'll also talk about some of the data that will help give context to how this relates to the clients that you represent that are defendants with drug-related offenses and have these overlapping disorders and/or possible mental health disabilities and cognitive impairments. And by the end of our presentation, we really hope that you will walk away with some practical solutions that ensure that you will be in a better position to provide effective representation to the population.
It's good to start out with some numbers. It's become really a truism depending on where you live, whether in New York City, Rikers, is the biggest nation's mental health facility. If you live in LA, the LA County Jail is. If you live in Chicago, the Cook County Jail is. What does that really mean? Well, we're studying this about 7 years ago, and Henry Stedman and his colleagues, in a very rigorous study, at that point in time, that almost 15% of male inmates and almost a third of female inmates had serious mental illness. But now, if you look at the numbers very, very recently, they skyrocketed. 40% of people on Rikers Island have some sort of mental illness. A 2000 study by the American Psychiatric Association revealed that 20% of all prisoners are seriously mentally ill. And these are very, very sobering numbers.
Yeah.
Our next slide is a snapshot, and you're going to get these PowerPoints in a few days, but I just want to really highlight a couple of pieces on them. Interesting for most of these how consistent the jail and the prison numbers are. 3/4 of all inmates of jail and 3/4 of all inmates at state prisons, all prisoners, met the criteria for substance dependence or abuse. And interestingly, on the question of mental health problems, 3/4 of all female inmates had mental health problems, both in jails and prisons. This is sobering. A bit of data, and this will be the last data we give you. Prisoners and 40% of inmates were taking prescription medication while incarcerated. And that's a very important thing to consider as we talk later on in this session about your interaction with your client, your first meeting with them, your counseling them. Think about the implications of this.
What's really important is that our clients, from the moment they hit our doors or their file hits our desk, these enter with substance use disorder. This is the population that we're talking about. Those clients who are ready to go to drug court, who have been assessed probably for drug court, that know from the beginning they have a substance use disorder. Now, based on just the statistics we just heard, we know that an overwhelming majority of them, 3/4 of women, and have some type of mental health issue. We should be screening people in for that they don't have a mental disorder or disability, rather than screening them out. There's a significant percentage of defense counsel, our caseload, will have this, they have mental disability. A significant percentage of our caseload will benefit from some type of voluntary mental health treatment. We know that that's also true. So whether they get voluntary mental health treatment, any other kind of treatment that's related to their substance use disorder, is going to be beneficial to the population that we serve. The individuals require specific strategies, this population, in the representation process. And we'll talk about that a little further on. What kind of things, strategies should we be embarked upon when we think or we know that our clients are likely to have a mental health disability, or they are cognitively impaired, or they are cognitively impaired because of their drug use. We'll talk about that. The statistics previously, well, Michael, why don't you talk about the other statistics regarding the developmentally disabled?
I mean, one of the other things to think about also is that it's a significant percentage, and it's very, very much even this hidden population. There's no question that the issue of mental disability is really hidden from view in so much of the discussion about this, but even hidden more deeply are people with some kind of cognitive impairment. And we have to differentiate here. People who are cognitively impaired because of drug use and drug abuse, people who are cognitively impaired because they are intellectually disabled. And there are also, that's a number, we don't have the exact number, maybe 4%, maybe 10%, maybe a little bit more. Many people, there are a significant number of people who are newly diagnosed in that way, people who are both cognitively disabled and mentally ill. But this is a population that's too often hidden from view, and I think it's very, very important that the defense lawyer keep this in mind, especially because so many of the people in this category have learned how to mask, have learned how to keep their disability in public view. That's a lot harder for you out there who are defense lawyers, you have to figure that out.
Can I just have you reiterate those statistics? For cognitive disabled
Right.
population, we're talking anywhere from 4% to 10% of those people in jail
Right.
may be cognitively impaired.
Right.
Now that's different than those who may have mental health impairments, which is, as we saw, which is a much larger number. So it is very likely that you will have a mix of people in your caseload. Cognitive impairment probably will be a lot less than those that have mental health disorders, but they're there. So when we see a client that has a confession in a case, we look at that confession and ask ourselves, is a confession that somebody gave who will, quote, or that person have some type of cognitive impairment? And maybe that should be the first question, because we know that that population is more likely to confess and is more likely to be willing to talk to police officers. They are very much more compliant than other populations, so they are more likely to be led down that path. They also may not have the requisite cognitive ability to satisfy the mens rea requirement in order to even be guilty or to plead guilty to certain charges. So they shouldn't even be entering a plea. But that might be in traditional court or in drug court. But all of those types of things we need to be mindful of. Now, we're not psychologists, we're not psychiatrists, even though I know we're supposed to act like we're psychiatrists and social workers.
We
and
just play one on
teachers,
television.
right? And we do all of those things. But the reality is that at the point that you have your clients assessed for substance use disorder, that professional, it's the professional who will be the one later down the road to mental health assessment, which requires a much more in-depth and a different kind of assessment that biosocial, psychological assessments by a clinician that's qualified to do that. But at the point that your clients are getting have been diagnosed with a substance use disorder, you only have part of the picture. When you get that part of the picture, that there's a 75% chance, if they're a female, they have an additional mental health problem. We know that there is at least a third of them will have other kinds of mental health problems. So we have to be cognizant of that as we go forth in trying to really advise them properly as to what the best decisions are for them. And we'll talk later about how that shows up in the drug court environment.
Absolutely, Yvonne. And the first thing Yvonne mentioned just then was about confessions. I mean, we know that being intellectually disabled is the first predictor of a false confession, going from a very simple misdemeanor charge up to a death penalty case. The Innocence Project's web pages are filled with stories of people who've been exonerated, usually by DNA evidence, but in a vast number of those cases, these are people with intellectual disabilities who fall confess. We know, but it's something to keep in mind. Representing somebody, related effect. If a person has a mental disability, an intellectual disability, what every textbook says, what every course in ethics and the law say you need to do as a defense lawyer: be candor, exhibit zeal, be trustworthy, have knowledge, be creative. But there's more, and this is really the core of what I want to talk about. Because representing these defendants, and I represented this population for years as a public defender and for years, director of New Jersey's Division of Mental Health Advocacy. There are ethical dilemmas, there are process conflicts that you're going to be faced with, and to understand it, you have to understand these are factors that are on this slide that infect the entire representational process. Maybe familiar with them, maybe not, but I think if you take away from my part of this talk, it is to know what these are and see how these appear all the time in court, and I might say, also appear in what you do. Same creatuality, mystic reasoning, and false ordinary common sense. So what is it? Like sexism, like ethnic bigotry, like homophobia, it is irrational prejudice. It relies on stereotyping, on typifying, on slotting. It people as less than human. Our fear is sanest when it comes to defendants with mental disabilities, whether they're in drug court or whether they are on a capital trial. And when I say we, I mean all of us. Judges, prosecutors, court personnel, jurors, and defense lawyers. Hey, I'm a defense lawyer, but defense lawyers can be just as sanest as anybody else. Protectuality is on the shoulders of the judge. The way the judge accepts and sometimes almost demands testimonial dishonesty from witnesses to testify in the way the judge wants them to, even if it results in a deprivation of liberty, even if it has a relationship to case law says or what the statute said, because it's the way the judge wants the witness to come out. Your fancy word, it's a cognitive psychology construct that says we try to make our thinking simpler. We try to simplify thinking, process information. There's all sorts of heuristics. I've written about this a lot. The very end of the slide, the last page, is a bibliography. Got a lot of my stuff there. I'm just going to use one, the business heuristic. News at 11 o'clock tonight, local action news, and your story about a person with a mental disability who commits some kind of an inexplicable crime. Watching news, immediately say, well, if this guy did that and he was mentally disabled, we assume that everybody with a mental disability is be dangerous like that. That's demonstrably wrong. Well, that's how the public feels. And the ordinary common sense, it's false. It's self-referential. It's non-reflective. I think that way, therefore everybody thinks it that way. I think this way, therefore it is. And just exhibit this day in court. I'm going to talk about that a little bit later on. These four factors, and this is from my whole career, kind of accumulated, dominate the entire representational process and the court process of criminal defendants with disabilities in regular criminal court, in mental health court, in other problem-solving court. These are toxic, and lawyers must understand their toxicity. So, what do we do? And we're, as Yvonne said, we are not therapists. We're not clinicians. Faced with a client, we have to make snap decisions. How to do these identifications? We'll talk about it in a bit. But before that, a couple of other things. Thinking myths that adhere to these populations, how we differentiate between people with mental illness and intellectual disabilities. Word up, many judges do a very, very poor job of this. Every year, there are reversals by appellate courts of judges who mistook mental illness for intellectual disabilities. It always happens. And what counsel have to get these, and how is it that these are often so much more toxic in a drug treatment court, any kind of problem-solving court. The next slide, I'm not going to go into. This information comes up later. Basically, on the left side are people who are cognitively impaired or neurologically impaired, what we now call intellectual disability, used to call developmental disability or mental retardation. On the right side, mental illness or psychosocial disability.
Let me just stop you, Michael.
Please.
That also includes autism?
Yeah, I mean,
on the cognitive impairment,
absolutely.
neurological impairment.
And autism is a separate issue. Autism, hint to Caroline, is definitely worthy of a webinar series in and of itself. You know that. I'm smiling. But that's something. And when I was practicing criminal defense law, no one knew what the word autism meant. And I think back, everyone's like, oh my God, a certain client, a certain kind of a problem, must have autistic. I didn't see it. Nobody saw it. What's important here is, if you look at these five, I've identified 5 different areas to think about. This is posted on your computer. In diagnosis, in the longevity of the disability, the different onset of disability, in whether or not the role of medication, and the difference in what kind of professional assessment is involved.
Let me interrupt you. Those 5 posters that you just posed, correct? They apply to both categories.
Exactly.
They apply to the cognitive and neurological impairment category as well as the mental health category.
Right.
So you need to make sure those post-it notes in your brain also they apply to both groups. I'm looking at the cognitive impairment. The challenge is here.
It seems to me there are multiple challenges here. Firstly, we do know that, notwithstanding the fact that intellectual disability is lifelong, we know with education, with life skills training, there can be significant improvement in this population. In the 1970s and 1980s, there was a plethora of litigation representing people with these disabilities, and the evidence, the valuable evidence was clear. There can be improvement here.
But we are still talking, remember, we're still talking about people that are, that have substance use disorder as their primary diagnosis, at least when they come into the court. And this population may have been somebody who was part of a drug operation, and maybe they were the one who carried the drugs. This is the kind of charge you might find somebody who carried a bag and on the street, and they really didn't understand the full scope of what they were being involved with, but nonetheless criminally responsible. They may understand their rights, but they could never really explain them to you if you really ask them. They may have trouble with short-term things like phone numbers and addresses and other kinds of information. There are ways to kind of get cues, but the population is, as we said earlier, a smaller part of our caseloads, less likely to be in our caseloads, but they are there and they are hidden, and we have to certainly recognize them and do what you do to screen. I should just stop and say, depending on the organization, whether it's a public defender entity or a private counsel, if you have a contract lawyer who represents the client, how these things get paid for. It's an organization like an institutional public defender. The public defender's budget you can go to your boss or to your supervisor and ask for a request to have an expert, assess this person. The court may take on that cost sometimes, but sometimes it's very hard to get a judge to approve. They might not see the reason why you need to even have somebody assess. But with data we've provided you, I think we should try to be making arguments that it makes more sense to have these people screened out. Let's have the assessment anyway and find out whether they are or they are not impaired or have a disability. Let's move to the next slide.
I want to say one thing. When we move on to the next slide, that's okay, something to flag that's not here, and I didn't think about this, Yvonne, until I said what you said. I found this out years ago when I was writing an article. In many cases, persons with intellectual disabilities were actually charged with heavier drug crimes because they were used as the mule. Yeah. They were used to take drugs from one place to another because they really didn't quite get it. You may find paradoxically that this population have the most serious felony charges on them, which may have an impact when it comes to the drug court, because the drug court judge is rifling through his cases, he sees possession of, personal amount, and oh my God, this guy's holding, how many grams,
and for a myriad of other reasons, they even might spend longer in jail.
Exactly.
So let's go on to, and we'll talk about then how does it work for them in drug court? How do they function? How do they comply? How is their compliance? And how can we make sure that they succeed if this is a good environment for them? Let's look at issues regarding mental illness.
Most of this is pretty self-explanatory. I just want to spend a couple of moments on this slide. Number one, the nature versus nurture debate is raged for hundreds of years on what causes mental illness, but we know this. Environmental factors are important. Many of our clients come from incredibly disorganized homes. Many of our clients were abused as children. This all matters. The biological factors can be exacerbated by environmental factors. The lawyer have to be aware of this. We also know there's something, iatrogenic illness, fancy word, that people get worse very often from being in a hospital. No question about that. We have to be aware of that. To know. So the medications say, why doesn't he just take his meds? Well, one of the sides of just taking his meds is a person may suffer, especially given the wrong medication in inappropriate doses, from irreversible neurological side effects. Tardive many decline cases.
Can you say that again, slowly?
Tardive dyskinesia. Tardive means late in onset. Dyskinesia means kinesic is movement. A person makes worm-like gestures of their finger, rolling of the jaw, the eyes. The person you look at on the street and say, oh my goodness. The reason the person looks that way is the way that person was medicated. Okay. Rennie V. Klein that I cite here, which is I supervised the litigation of the late and early 80s, is best explanation in any published American case of what this disorder is. And I suggest that every lawyer representing people with mental disabilities who have voluntarily medicated in their lives read this case.
And it's very interesting that many of the clientele have never had access to psychiatrists,
Right.
have not been diagnosed.
Sure.
They may not have had any previous diagnoses, correct?
That's absolutely right.
Also, to the extent, let me not backtrack. I want to talk about the cognitive use disorder. We didn't talk about that. So next slide and say, how does this manifest in the drug court environment? Show up. Well, for those of us who are practitioners, I should say, before we even go down this list, I think it's so important for practitioners out there and defense, the people who are making decisions, administrators and public officers, to understand the importance of individual representation all the way through drug court. There's a need for representation, not just at the beginning when we enter people into drug court, then you wave goodbye and say, I'll see you, and hopefully they come out on the other side. Or and it's not always the fault of the defender organization. They may not have the manpower to put a person in court every week, but it is so critically important that counsel is present through drug court at every stage, at every staffing, because kinds of issues that are manifest that you may not see, they may not show up as some illegal behavior. And if you look at the slide, you'll see that, there are a couple of things that we see that are typical. Are your clients constantly tardy? Tardiness is a big flag, and it might be a flag. We're talking about, why is this a flag? This is a flag for mental illness. We have a substance use disorder, but what about tardiness that makes us know that they have a mental health issue? Well, maybe they're severely depressed and getting out of bed. Maybe they have some elevated mood disorders, or they're cognitively impaired and they can't function like other people function. So tardiness might not be because they really want to tick off the judge and they can't get there on time. An average person, we look at it like, what is the matter? You can't get here at 9 o'clock or 10 o'clock. Well, maybe you should move your court day, which is what we did, to 2 o'clock in the afternoon. And quite frankly, our tardiness levels drop. But just one example. Are not engaged in what is going on around them. Is there the belligerence or anger, always ticked off? Never smile. And don't tell them to smile. That's something you can do is say, why don't you smile? Like, what are you talking about? I don't want to smile. Maybe there's anything to smile about. Maybe, by the way, anger is another indicator of underlying mental health disorder. Not motivated, which was always curious to me because I wasn't sure what that meant. And it may mean a lot of things, or it may mean nothing, but motivated is another indicator. Dirty UA. Dirty urine, maybe, yes, you might just be using, but you also may be self-medicating. There is a very big difference between someone who needs the drug or the weed to themselves feel whole so they can actually function. And it's addressing that underlying disorder that professional needs to help. So it might not just be a matter of, I just want to use. It might be, I just can't function. I have this. The PO is out to get them. Or whenever there's a graduation or a commencement, that's always, they always think is their PO. But again, the person who's giving them brief, who's out to get them. Social skills, their instincts are off balance. They're improperly relating to family members, or there's no communication, blame others for what's going wrong, disorganized in their thinking, disorganized in their day-to-day. They're not doing their diaries. They're not getting to where they need to be. They're not following instructions. Sending irrelevant responses. You ask them about how things are going, and they tell you something that doesn't mean anything to nothing. They're lacking in their life skills. Cannot get to an interview. Cannot get to the bank. Or they have difficulties just keeping themselves together in the home. Or losing places to live. Things of that sort. Now, treatment environment, course, I'm a treatment specialist, but our treatment specialists tell us that things that we see are not working in their group, not attending AA or NA meetings, not completing workbooks, not working the program, as they might say. Again, tardiness, inappropriate outbursts. We're in group, and we're talking about something very sad or very tragic in a person's outburst of laughter. Totally inappropriate, and you don't know where that comes from. Well, what is that? Extremely sad or mad. Again, elevated mood disorders, another reflection of bipolar, elevated mood disorder, depression. Of course, depression is always in a depressed state, and bipolar may be that elevated mood disorder. Sleeping during group, which would be an indication that there's been insomnia. Insomnia is another indicator that we see. You're disorganized again in thinking and social interaction. So these are the kinds of things that if you, and I'm sure all of you recognize these things that you've seen with your clients, but how does that manifest in a way that is probably hurting your client because they're not being compliant? And so if we have identified if we take the time to ensure that we identify the underlying mental health disorder or the cognitive impairment, you can then tailor their treatment plan and program so that they are on task. Again, this is why we need things like multiple tracks so that we can, that courts in generally and treatment courts tend to be very rigorous. There's so much expectation, but I have to really understand that maybe these individuals who are suffering from this mental health disorder or disease are incapable of doing the rigors of the program. And we have to be realistic about what they are capable of doing. And now, they will get better, at least we know that some cognitive disorders, they're not going to repair when there's cognitive impairment. But if you've had cognitive impairment as a result of substance use, you may be better, correct? Correct. And if your mental health ability, if there's medication involved, if you have the right kind of psychiatric and psychological counseling, you can do better and may function better and may be able to do so without using substances to self-medicate. So it's really in need for two things: the individualized treatment program, and I should add to that psychiatric and psychological counseling, individual counseling, and multiple tracks that can help, whether it's a mental health track or a special track for those individuals that have cognitive disorders, or a track for those that have mental health disorders, because you'll be just treated very differently. But it is about individualized treatment, which is consistent with the 10 key components. But it is something that we have to try to really toward. And the pressures, and you all know as counsel, the pressure are on us. From the moment that we hit the courtroom, the judge wants us to get moving. People have been sitting in jail. We have piles of work and clients who need our attention. Now, you've had the luxury to go to the jail, sit down quietly, and meet with clients. I actually hope that that's possible, because that's really the best way to do it, because you really want to have a treating relationship with your client so that they can impart to you the information that you need to help them as you represent them. And that is only going to help. You only get that information if they trust you and are willing to share that information. But the reality is, you and I both know that somebody's going to come to the holding cell who's been in jail for 3 weeks, and the judge is going to say he is a plea. Prosecutor, we want the crisis of the moment, and as a 10 key components, we want to use the crisis, the arrest, to mold them into treatment. But there are so many unanswered questions that we're now learning with the answers to before we, or the courts have to be progressive enough to allow the programs to give time for these assessments and mental health evaluations to take place without pressuring people to take the plea, or if they're going to take the plea, to give them the latitude to change the requirements of these people based on what those fines are. And you can't do that in advance, and you certainly can't do it in a vacuum. But And so we need to get a quick handle. So I'm walking, you're coming out the holding cell. What am I supposed to know? I'm looking at you say to me, and I'm trying to figure out what am I supposed to do with you?
I mean, that Yvonne, you've just put your finger on it. You come to the holding cell, and you look at me, and I look okay to you. What are we talking about that? Right. Let's go on to the next one. The question of let's look on to the next one about visual cues. I'm going to start with the worst because we have the most evidence about this. Penalty cases are the worst. Insanity defense cases. Jurors look for visual cues and clues. Remember what I said about ordinary common sense. Does the defendant look remorseful? Does the defendant look, quote, crazy? Does the defendant look off? We have our own database of what we see, and our database may come from an N of 1. It might be a relative we have. It might be a neighbor. More likely, it's an episode of Criminal Minds that we saw, or Law and Order, that are making these kinds of judgments. Criminal defense lawyers generally any more sensitive to this than the general public. We have fixed visions, popular visions of, quote, craziness. As a result of that, we both over-include and under-include. What do I mean by that? Next one. Right. If some, quote, looks crazy, end quote, they may not be. Remember what I said earlier about tardive dyskinesia. They may have been mentally ill at some point in time in the past. Now they have this neurological condition, has nothing to do with their mental state today, but the way they look, the way they appear, is going to speak craziness to you. It may not be. On the other hand, if it kind of, quote, looks normal, they may not be. We know many people with schizophrenia are very brittle. They're very quiet. They sit in the corner. They don't talk. They don't interact. Those might be the most mentally ill people, but they don't present that way, so we ignore it. And judges are the guiltiest. Again, what I have in the very bottom of this slide, the defendant doesn't look sick to me, as the judge can assess this, or is as healthy as you or I are. I mean, talk about what that means. What we have to do is how the client presents. Look at how the client interacts. Look at how he or she talks.
Affect.
Affect, exactly. Are they inappropriately laughing or crying? And Yvonne earlier talked about people, treatment team, somebody says something that's very sad, and people kind of laugh spontaneously. That's an important clue. Are they responsive to questions? Now, on irrelevant topics, be very careful. Because what you're the defense lawyer. You got a stack of files like this. You got to be in Judge Jones's court in 20 minutes. You get these things done. But what's important to this client may not be this charge. What may be important to him, the fact that he's threatened with eviction, or the fact that his kids' welfare benefits are being threatened to be turned off. That may matter much more. So be wary about irrelevancy. His irrelevant thought may be, in fact, very relevant. What you want to try to do is engage him or her in what should be in an anxiety-free conversation and see how they respond. And my pizza parlor example, this may sound trite, but it always kind of worked for me. Not always, but it often worked for me. I'm in Trenton. I practiced law in Trenton. I knew all of Trenton's pizza parlors. So somebody lived, and they say, oh, you Lower Ferry Road. Hey, you ever Palermo's for pizza? And then I would see, I wouldn't even tell him it was my favorite pizza place in town, which it was. I wait to see what he says. Because there's answers to that. And I think the anchovies are great, and we talk about that. That is going to give me a suggestion that I can communicate with this guy or woman. They have some kind of a disability, but not so much as to impair them to make problematic for this court. But if they're very rapid or very slow, or what do you mean? That's a question.
There are also some other things. Has the client been on medication? And I think that have your clients, we should also get them to sign authorization so you can gather medical information. Maybe they've been receiving a medication in jail. About what they're talking about. Are there inappropriate movements? Are they rocking? Are there certain behaviors that don't seem, quote, you? Those are kind of obvious. But it's really the harder question are the persons who are quiet or maybe not doing much of anything. I want to go forward because we don't have much time. I want to flip forward to the cultural slide. I think that there are some important things we need to just talk about, and I don't want to lose this opportunity. That there are, depending on who you are and what cultural background you come from, you may not talk about your mental health disease or disorder.
Right.
There are issues of shame.
It's shameful to talk about it.
It's shameful to talk about it. Certainly within the African American community, there's a lot of issues around culture and whether to even use a psychiatrist or a psychologist or a therapist. There are some communities where you just chat about it. Oh, how's your therapist? And it's great. And other people, you go, why would you use a therapist? If I have a problem, I go talk to my pastor or to the people in the community.
Bartender.
There are other cultures that whether it's eye contact, and we've talked about these things. So whether people don't want to talk about it, and by the way, the culture within the prison, you talk about things like this in a mixed community where other people can hear. In fact, people often mask their disability, even come across as non-compliant, don't want to show that they have a disability. So if say I'm not doing my workbook, maybe I can't read, or I'm not doing certain behaviors because I just am not comfortable engaging in that. I can't do that skill. I can't engage in that skill. And to let you know I can't engage in that skill, I reveal my disability or my disorder, my cognitive functioning or my mental health disorder. So I think that we need to recognize that there's some cultural issues that also are present. I know that I
want to add the one thing here that on this slide.
We've run out of time almost.
Well, this will take 30 seconds.
Go ahead.
In some cultures, it is considered disrespectful to look an authority figure in the eyes. And I had judges say to me, Mr. Perlin, why does your client look me in the eyes? And the years that my client was told from the time he was 3 years old, especially someone in authority, and this would be a client of mine from another country, another continent, that the most disrespectful thing would be to do that. If the judge doesn't know that, you have to teach the judge. And that's an issue also.
There are other cultures where staring someone, you must look them in the eye, or you're guilty of something.
Exactly.
So I know that we are
just about done.
Carolyn,
we have two scenarios that we're going to discuss on our next follow-up session. But Genevieve, do we have one or two questions from that? Okay. So I hope that you will think about some of the issues that have been talked about, submit questions between now and tomorrow that we can address. And Genevieve, can you just go to the scenarios that we're going to talk about tomorrow?
And while she's doing that, I just want to wrap up, Caroline,
Sure.
just say, for representing our clients, do best to engage our clients early on, gain their trust, to not just of cultural differences, to screen in rather than screen out, to use the data to help major judges or administrators to authorize the funding that it would take to get special assessments and psychological examinations or other kinds of neurological or cognitive testing done, and depending and get, when you see your clients the first time, get releases and information and authorizations so that you can gather the information. Try to gather a list of contacts that your client has regarding their family or contacts, their support system, because those people will also be able to help give you information about who they are and what issues they may have if they don't remember or if they were too high at the time and over the years and they haven't been able to put that all together. I know we're out of time, so we'll follow up with our last our scenarios that we're going to cover. Right?
The last comment, though, I want to make is I think one of the themes here has been the underlying mental health, cognitive impairments that almost everyone that's involved with drugs has. And I'm hearing anecdotally more and more that when we have recidivism in drug courts for people that graduate, it's primarily because they weren't adequately assessed in terms of their mental health, particularly trauma, that's the underlying cause of their drug use. And so that they can maybe make it, as Yvonne said, kind of fake it for the program, but then it pitches up. So for those of you who are not attorneys, but I'm happy to see these treatment people and coordinators and others on the webinar, we just want to reiterate why the assessment and the ongoing assessment is so important. So we will follow up tomorrow and look forward to getting any questions that you have. Genevieve, anything you want to add?
We have a little bit of time if you guys would like to introduce the scenarios.
Okay. Then Yvonne, you want to introduce Mary?
So we're going to have Mary, who is a female, 32 years old. Okay, she's a female, so we know that 75% of the women might have an issue, right? You've learned that. Full-time fast food worker, brand new job. She's giddy. So she has one prior for DUI and a prior conviction for CDS. Now, what did Mary do? Mary left her two children home alone, ages 11 and 7. Now, that's not good, but probably when Mary was little, maybe somebody left her home at age 11 or 7 while working, so she was at work. She was driving home from work because of an expired inspection sticker. Bad luck. Her record check revealed that there was an outstanding bench warrant for a DUI. Okay, know what happened? She moved, right? Yes. She had gotten it was sent her at some other address. She denied knowledge of the warrant. She lives in a new address. The arrest, the officer at the part of the arrest found her in possession of without a prescription. And she was arrested for possession of CDS with the intent to distribute 60 pills, oxycodone, and endangering the welfare of her children. Unfortunately, we're placed into foster care. This is not usual, right? Mary doesn't have a great support system. She states that she is depressed, she tells you, and she once diagnosed with clinical depression. Her intake reveals she was positive urine screen for opioids, so she is positive US at the time of the arrest, even though home from work. And the first 2 weeks of the probation officer indicates that Mary often runs late for her early morning urine drops, and because she is late, that's considered a positive UA. You know how that goes. And Mary is now on curfew. Mary has also missed some meetings at night. So the issue is, Mary states that she is fine, but her behavior is inconsistent with her UAs don't show positive. I'm going to call. I want to finish reading that.
Sure.
I mean, she says she's not sad, but she's anxious to get her kids back. And racket, think about the stress that having your kids in foster care could put on anybody. She talks to anybody, she doesn't trust the system. And when people are seen as oppositional like that, that sort of, raises some issues.
So the problem.
What source of her resistance? Is clinical depression, and depression is, we talked about this the other night in another context. We use depression every day. The basketball team lost last night. I'm depressed. You know what that means, right? I'm sorry they didn't win, but that's nothing to do with clinical depression. It's a major mental illness, as serious and as toxic in its own ways as bipolar disorder or schizophrenia. Is it clinically like that under the Diagnostic and Statistical Manual or not? And how you help her recognize the fact that she may need clinical help, and how do we get her through the drug program successfully with all these issues? The scenario is one.
Before we go forward, we're going to go back.
Excuse me.
Yeah. But, let's just back up to slide 1.
Sure.
Right from the door, I think I said at the top, just the fact that she's a female.
Right.
I mean, statistics tell us that there's a 75% chance that she has a mental health disorder. We can also see, I think, from what we might determine, she's self-medicating.
Right.
Possibly.
I don't think.
Okay.
60 pills is a lot.
Well, but 60 pills, she's charged with intent to distribute.
Mm-hmm.
My colleagues out there would say, that's not intent to distribute, that's just personal use.
Yeah, exactly.
Right?
I would call it personal
use, but she's being charged with intent to distribute. So the question is this client that if this person goes into treatment court, and we're assuming she's going to get admitted into our substance abuse program, into our treatment court, what are the issues that she's facing with? And she wants her kids back. She's motivated for that. And what other challenges do you see, Michael?
Well, I mean, it seems to me there's multiple challenges in this case. First of all, the most important thing to her is getting her kids back. That's far more important to her than anything else. And I think she will, most likely, I've been thinking about some of the cases I've had, she'll say anything she thinks you or the judge want her to say to get it back. Whether or not this deals with it, does she have an underlying drug situation, does she have an addiction, we have no idea. It's not very clear that she does at all, although she does have at least one positive urine screen here. Why coming in late? See, I want to know that. Is she coming in late because she's working until midnight at the fast food place? Is she coming in late because she's working another job off the books that hasn't told anybody, including you, the lawyer, about? Maybe cleaning an office late at night and she needs some more money. Maybe she feels if she has more money, she'll get the kids back. So you need to find out. We don't have the full story here, and that's one of the issues. The question is, how can we, what role in terms of trying to persuade her to seek clinical help, and what are the downsides? Say that she says, wow, not only is she mentally ill, she might be dangerous to herself. I'm going to seek civil commitment on her behalf. They haven't done a very good job as her lawyer. That's another issue to think about.
Some of the people in our audience would think about this question, how they would handle it. Maybe some of you can send us a note and let us know what do you think, what would be some of the challenges you see in your court. Because something like this could very well be assessed under substance use disorder.
Right.
That assessment could happen. Sure. Based on what we figure. How does this person now function in our drug court and do so? But more importantly, how do we ensure that we assess her for that underlying mental health disorder they impact upon her ability to succeed in drug court and be compliant with the rules of the program, that she can be successful in the program and hopefully get her children back.
And when you send us those notes, please tell us, are you a public defender? Are you a drug treatment worker? I would like to know what your professional background is, because I'd like to see what kind of correlation there might be between the responses and what your role is.
I just have one question, and I hope people will send in some comments now. But what about contact with a child protective worker? Is that something that you would do?
You know, Carolyn, this gets me off into a completely different set of speech. You and I talked about this, I think. I don't know if any of you are in New York City, if any of you are in Brooklyn. This court at Hook, the Center for Court Innovation, I think, Community Innovation, that Alex Calabrese runs, one of those courts where it's very easy to get the defendant connected with child protective services, to get connected with housing services. If we did this more, if these problem-solving courts were more correlated with the others, my God, our jobs would be easier and it would be so good for our clients. But yeah, I would, if I'm a public defender representing her, my first call after I'm done seeing her is talking to whatever legal aid society there is in my county that does child protection cases and saying, I got a client.
Well, for resource-rich communities, that's an easier answer. But in the high desert, if you're rural communities and small communities where you don't have that resources available to you, it's a much more challenging dilemma, and you don't have as many options. And so this is a much more difficult challenge in certain communities. And so you have to then think outside the box. Are there in your community, universities that are nearby that may have other master's level support, or that work with this population? You might find people in training, but I mean, it can be a very challenging.
I mean, it's totally a challenge. But actually, just to build on what Yvonne just said, and I've said this in other instances. If there is a university near you, especially a university that has a medical school or has a graduate school of psychology, one of the things you need to do as a public defender is to make a connection with a person who runs a psychology program, runs a social work program, runs a forensic psychiatry program, and see if there is a way of using their fellows, using their PhD students or their postdoc students to work with your office on cases like this.
And as a public defender many years ago, but there also there's two separate systems there. And so I think it's extremely important to connect with a child welfare system that could be proceeding with the foster care and whatever else they're doing, to let them know that Millie is hopefully seeking help and connecting with her children, getting the visitation started, and bringing them into her world, because systems are parallel and have no connections at all.
We have time to talk about one now or not? What's it?
Why don't you introduce scenario 2 and so people can start thinking about these?
Okay.
So for the follow-up session tomorrow, hope people can flesh their ideas a little bit more.
Okay. 126, 2 prior convictions, and a CDS and a theft. He's in the backseat of a car. It stopped at midnight for speeding. The car is determined to be stolen. And in the backseat, they find cocaine under the front seat passenger side. He denies all knowledge. He is reported by the police to be under the influence of drugs. We don't know if there was any kind of roadside test or whether his eyes looked glassy or whatever. Charged with everything, and he's offered a deal. Drug court and unsuccessful completion of drug court expungement. Now, again, in some of the jurisdictions, I don't know what states all of you are from, but some states in which I believe you, our audience, are from, expungement is possible. In jurisdictions, it's not. The person still has to plead guilty, be put on probation, and the felony is on his or her record. And for the issues raised by Padilla versus Kentucky, there's all sorts of other issues to be raised about pleading a defendant to a felony, and I think that's one of the things you've got to process. He's in post-adjudication drug court. He's not really doing much of what he's supposed to be doing. The program wants him. He wants to go back to work. Program wants him to focus on treatment, and he's diagnosed with bipolar disorder, a very, very serious mental illness. He doesn't want medication. He wants to feel normal. The program says if you don't take your medication, you're going to be terminated. You do. An extraordinarily difficult question. One is made even more difficult because I alluded to this before. In many jurisdictions, there is case law about the right of psychiatric patients to refuse medication. I don't know the case law, if it exists, on the right of drug court defendants to refuse antipsychotic medication. I don't think that's ever been litigated in the appellate court.
I haven't seen it yet.
Right. And that is the second scenario. The last 2 pages, the last 2 slides are simply our bibliography. What time? 3 o'clock.
Yeah. So we come to the end of a really packed hour. We thank you for joining with us, and we look forward to our follow-up session tomorrow at 12:30 Eastern Time, where we'll talk about Juan and talk about some of these other issues that have surfaced in the course of this discussion.
And if you have any questions, please feel free
We hope that
email us.
We hope that and send in through the web. I see some questions that are coming in. No, yes. Okay.
No.
People
One comment, Kevin.
thinking. Okay.
The one at the end.
Is there,
Sure.
Are we off?
We're still on. So we received this comment from Leanne Hunter, who's a public defender, and she just said, you have to be careful involving Child Protective Services agencies, though, because that can lead to the removal of the children, which will add more stress. I represent parents in CPS cases as well as represent clients
Totally
in
agree.
WI
I totally
Agree
Absolutely.
100%. Yeah.
and
Thank you for that comment.
Yes,
and
thank you.
we hope that you will take everything you got here and apply it to both the legal structure and the legal culture of your local jurisdictions, because that's really to how to try to impart here usable.
So for tomorrow?
We'll see you tomorrow at 12:30, hopefully, and have more questions, and we'll discuss Juan and some other issues. Thank you.
Thank you very much.
Invitation.